Good evening. Welcome. Thank you for joining us. Welcome to this Brick Court seminar on commercial litigation, hot topics and key pitfalls. All sounds very dramatic. Some of us know some of you know some of us. That's not enough. For that reason, we will get through the seminar and then invite you to have a drink with us and hopefully get to know all of you quite a lot better. Over that, we're going to have drinks around the corner and up in the mezzanine level. I see from a recent edition of The Lawyer that they sent, I think, a whole team up here in March, or at least that's what they said. And they said that Manchester's legal scene has regenerated as fast as its skyline, and it has become the UK legal market in microcosm. No doubt you all read that with a sense of happiness and satisfaction. That's certainly our impression and what brings us here to meet you today. We've got quite a limited time for what we want to get through, 4 different presentations. So I want to move into the substance quite quickly. Just to introduce you, we've got Joe Box, I'm Thomas Plewman, Richard Blakeley and Kyle Lawson, and that's the order in which we will be speaking. The challenge of a seminar like this is to try and find some things which might be of interest to you, but won't take too long, won't take too much detail, won't bore you to tears, and some things which have some topicality associated with them. So I think, as you know, what we've arranged to speak about is we've got Joe talking about getting your claim off to a good start. Would that we always did so. But an interesting selection of points on that theme. I'm going to talk about really the other end of the problem, benefits which reduce damages, which is a topic which I think is often doesn't quite get the attention that it ought to get. Richard Blakeley is going to talk about misselling of financial derivatives, and Kyle will talk about some aspects of privilege in the Property Alliance Group litigation. And hopefully that will stimulate you also to ask some questions. It seemed to us that having questions after each section, as it were, would just be too stilted. So what we'd ask you to do, if you do have questions, is to hold them all up for the end, unless there is something that is so burning you feel the need to ask it immediately, in which case by all means. And of course it may be that ultimately your questions can track through to a time when you have a drink in your hands, and that would also be very welcome. So can I ask Joe to speak to you first? Thank you.
As Tom said, the aim of this evening is really to sort of talk to you a little bit about various things that come up a lot in our practice and things that we think might be helpful. Tom, Richard and Carl are all going to talk in a bit more detail about quite narrow areas. My aim for my talk was to start with something a bit more general and to sort of look at some of the things that I see going wrong quite a lot that I think could be solved with a sort of bit more of a checklist at the beginning and just making sure that all of the I's get dotted before you embark on your claim. Some of this stuff is obvious to most of you. Some of it, in hindsight, always looks like it should have been obvious. But I hope that thinking a little bit now about the sorts of issues that you should have in mind when you're getting something off the ground is helpful and will sort of help next time you're in this sort of situation, some of the brain cells to sort of ignite and for you to remember some of the issues that certainly I sometimes overlook, and I'm sure everyone else does. The first thing to think about when you're starting a claim, and this is obvious in a lot of cases, is who are the parties. And you might say, well, you know who the parties are. A client comes to see you, they tell you that they've got a claim against somebody else and they want to get it started. Often you're under some time pressure, maybe there's a limitation issue, and the sort of focus is just on working out what the claim is and getting started. But sometimes it does benefit you to sort of stop and work out exactly who it is the party should be, particularly when you've got quite complicated corporate structures, which we increasingly see. actually the party you have the claim against might not be the obvious party. It may be that there are 3 or 4 different corporate entities that are attached to a particular contract, and actually taking the time to think through which of those you can claim against is much better done at the beginning than down the line. I had one case recently where a very good firm of solicitors trying to bring a claim against a bank, and one of the associates had Googled the bank, had a look at some of the different entities, guessed that this was probably the right one, and decided to just stick that on the claim form, which somewhat came unstuck when it turned out that actually that entity had nothing to do with any of this particular area of work and that it should be someone different. And you then have the hassle of explaining to your client why it is that you actually need to go and change that. So do always take the time to double check that you've got the right parties. Similarly, it happens surprisingly often, make sure that they still exist. You often find that the company you think you can claim against is no longer on the company's register. So check that. It doesn't take very long and it saves embarrassment down the line. Obviously, you're all aware of this. Be alive to things like bankruptcy and insolvency. Are there any issues here? You need to deal with them up front if there are. And most importantly, I think, try to be comprehensive at the beginning. Often, your real claim might be against a particular corporate entity, but you might want somebody else to also be bound by that decision. If that's likely to be the case, adding them right at the start is obviously easier than trying to bring them in down the line. So always do have in mind, as you're getting started, have you covered off all of the bases? The next thing to think about, and this is something that actually I see going wrong a lot, and that is a bit more technical, is making sure that you don't get caught in what's called the reflective loss rule. And what this is all about is when you're dealing with claims that can be brought against a company, the law prohibits you from trying to bring a claim on the part of the shareholder for the loss of the value of their shareholding or their dividends. It's a rule that dates back to 1843 in Foss and Harbottle. For a long time it was seen as something quite niche. It didn't come up that often, but increasingly I'm seeing more and more cases where this becomes a live issue, sometimes at a summary judgment type stage, sometimes further down the line. And the basic rule is that where there's been a wrong done to a company, the only person who can sue in respect of that wrong is the company itself. And what that means is that a parent company or a shareholder can't claim for that same loss in their own name. The leading cases are on the slides. There's a House of Lords decision, Johnson and Gorwood, and then Court of Appeal decisions more recently in Giles and Rind and Gardner and Parker. The rule itself is quite easy to state, but there are 3 exceptions to be aware of. First, you can nonetheless bring a claim, even where there's a company involved, if the loss that you're claiming is distinct from the loss that was caused to the company. So you have to think quite carefully about whether there's any overlap. The courts have made it quite clear that things like dividends or loss of value to shareholding will fall within the scope of the rule, but you may well be able to identify other losses that don't, and if you can claim for those separately. Secondly, there's an exception when the company itself has no cause of action. So an example of this came up back in 1956 in Lee and Sheard. And in that case, a defendant had negligently driven into a claimant, knocked him over, caused him to have to go to hospital. Because he was in hospital, he couldn't run his company properly, and the company made less money that year and paid a smaller dividend. And that was a case where actually the company itself didn't have any cause of action against that driver. The driver hadn't directly caused any harm to the company. It was just that by causing harm to the individual who he knocked over, it resulted in the company's finances being in a worse position. And in that case, the court said actually, as the individual, he could sue for that damage. And the third exception, and this is often the most complicated and the one that comes up most regularly, is that the rule won't apply where the company is unable to pursue its claim against the wrongdoer because of the wrong done to it. So what often happens, and this is what happened in Giles and Rind, is that another party causes loss to the company. In Giles and Rind, it was a case where another party had stolen clients from the company. As a result, the company was in difficulty. It ultimately went into liquidation. And when it tried to bring a claim against this other party, the other party said, well, we want security for costs. Because the company was in liquidation, it couldn't put up security for costs. So it was effectively prevented from bringing its claim. And in that situation, the court said, actually, a shareholder can bring the claim here, and that's fine. So when you're looking at these sorts of cases, you often get, particularly, say, a wealthy individual who structured his assets through a number of different corporate entities, often wants to bring a claim perhaps against a bank or another institution. You have to look very carefully about which entities might have a real claim and work out exactly who the correct claimant is. And often the safest approach might be to join a number of those different entities so that if it turns out down the line that this rule applies, the claim can still be brought in the name of someone else who's already on the claim form. But it is something to bear in mind. I think as people are becoming more alive to this, there have been quite a few first instance decisions. More and more defendants are choosing to take this point. So it is a thing to bear in mind whenever you've got a company involved in the structure that's bringing the claim. The next topic to touch on, and again this is something you'll be very familiar with, is causation. Often I get instructions or I see claims where there's very obviously a wrong that's been done to someone, there's clearly some loss that's been identified, but there isn't always enough work done trying to join the dots between the two and to show that actually this specific loss has been caused by that wrong. When you're looking at something like this, you have to sort of ask yourself, is there a causative link, or would the loss have been suffered anyway? And that happens a lot, for example, where there's a market downturn. Even if there's been a breach of contract somewhere historically, if in fact the market is such that the business would have done worse regardless of that breach, it's not going to be possible to recover that loss. So you have to have in mind, is it the effective or dominant cause of the loss you're trying to seek? Similarly, if there's a third party who intervenes somewhere down the line, you have to think about that and whether you think that might break the chain of causation. So it's something that often is quite straightforward, but it is worth trying to spell out when you're getting the claim off the ground, how you're going to show the direct link between whatever your claim is and the loss that you're seeking to recover. A point that people often forget when they're looking at this is what you have to show in terms of the defendant's performance. And this is important when you're looking at any sort of breach of contract claim. Often a client will say, well, if they'd complied with their obligations in the way that they'd done in the past, all these wonderful things would have happened, none of this loss would have been suffered. But in fact, the way the courts have analysed this, and this dates back to Laverack and Woods, but the most recent decision on this is Durham Tees Valley and BMI Baby. The courts require you to show only that the defendant would have met the minimum standard of performance. So if, for example, the defendant had rights to terminate the contract, or if in the past they'd been acting above and beyond what they absolutely had to do, the court will say, what is the minimum they could have done? And that's the basis on which damages get assessed and causation gets assessed. So it's quite important to keep that in mind when you're thinking about the alternative scenarios between what in fact happened and what you're saying should have happened if nobody had been in breach of the contract. The other thing to keep in mind is the loss of a chance jurisdiction. And again, this comes up quite a lot. Normally, some months down the line, after a case has been pleaded, where you have to start to work out, in a hypothetical scenario, how you're actually going to assess damage and what sort of losses you're likely to be able to recover. And the rule here, and it was looked at quite recently by the Court of Appeal in Wellesley Partners and Withers, sort of 2015 judgment. is basically, if you're looking at the hypothetical actions of the claimant, those have to be proved on the balance of probabilities. So if the claimant says, if the defendant hadn't done this particular thing, I would have gone and made this decision and this is how I would have acted, you have to look at whether or not there's enough evidence to establish that on the balance of probabilities. If, however, you're looking at a third party, and the normal scenario when this comes up is when, say, the claimant says, well, I've lost a business opportunity. If it hadn't been for this breach of contract, I was going to get this very lucrative contract with somebody else that was going to make me a lot of profit, and I want to recover those profits. And often it's an extremely lucrative contract that they say, 100%, I would have got that contract. It would all have been wonderful, and we'd all have made an enormous amount of money. The court won't let you simply say, well, on the balance of probabilities, probably I'd have negotiated that contract and it would have gone through. They require you to analyse this on the basis of loss for chance. And what that means is they'll work out in percentage terms how likely was it that that contract would have been obtained with a third party. And it doesn't matter if you can't show that it was more likely than not. It's sufficient if you can show a 20% or a 30% chance that that contract would have gone through. But what the court will then do is look at the loss you're saying you've suffered because it didn't and apply the percentage to that. And often it's important for clients to bear that in mind because say the court decides that there was a 40% chance that you would have been able to negotiate that contract. That means that you'll only get 40% of whatever profit you say would have been obtained. And that might make a very big difference to the numbers in terms of what your claim is worth. And obviously, as the claimant, you'll say, oh, actually, it was very likely, it was 80%, 90% likely. But you do need to bear in mind at the beginning, that makes quite a big difference to the value of your claim. And it's a different way of analysing it to simply saying straightforward causation, balance of probabilities. And it's worth thinking about that when you're advising claimants and getting something off the ground. The last area, which again, you'll be very familiar with, remoteness, making sure that things aren't too remote, that you can say the other side knew or should have known about this particular type of loss, comes up day to day. One issue that I see quite a lot is an issue where the claimant will say, when this breach first happened, I told the other side that I would suffer all of these losses, so they knew about them, so they're not too remote. And the problem with that is that when you're assessing remoteness, you have to look back to what the parties foresaw at the beginning of the contract, rather than at the time when the breach was happening. And often the beginning of the contract might have been several years earlier, and it might be that none of this was foreseeable then. So it's quite important to have an eye, particularly if you're looking at quite special damages, for example, lucrative contracts, claims that they say they would have been able to negotiate, that sort of thing. You do need to have in mind, is this the sort of loss that when they set out on this contract, they might have foreseen? The last point to think about, and this is actually a sort of a positive for claimants, often you get a situation in remoteness where a particular type of loss leads to a very big number on the claim because, for whatever reason, the loss of profits ends up being a quite significant sum. And the response you get back from the other side is often, this wasn't foreseeable, how could we have known that you'd have lost this much money? And in that scenario, the law does help you out because you can fall back on the fact that it's only the type of loss that has to be foreseeable, not the extent. And I think that's something that's often overlooked when people are on the other side of the fence as the defendant, trying to look at what they can knock out and how they can respond to the claim. So all you've got to do when you're establishing remoteness is show that that particular type of loss was foreseeable. It's just important to make sure you think about it at the time and ideally make sure you plead it so that when you come to things down the line and you're preparing your evidence, it's clear on what basis you're making your case. Those were all sort of reasonably high-level points, but I hope that they sort of help just in thinking about some of the things that you do need to keep in mind next time you're thinking about these issues. I'm now going to hand over to Tom, who's going to talk in a bit more detail about a narrower point, but a point that, again, we're seeing coming up a lot, and where I think the scope for sort of being alert to issues from the outset. Thank you.
See if I can operate there. So something much more specific, although linked to causation and some of the areas that Joe has been talking about. Benefits which reduce damages, and I've described it as progress denied because there were 2 decisions of the Court of Appeal in the last year that, depending upon your perspective, had the potential to move the area on a little bit and give some greater definition to the principles, and I think balked at doing so and drove us back to where we always were, which is a sort of touchy-feely proposition that I will get to. As I said in introduction, I think it's a topic that is often given a little bit too little attention, whether on the claimant side or on the defendant side. On the claimant side, obviously, it holds the disastrous prospect of reducing what looked like quite a good claim to a claim that's not worth very much. On the defendant side, equally, it is an area of great opportunity to bring a claim into realistic proportion. It arises, so in the introduction, now why is that not? It is linked to, and you can see on the slide, the 3 rules for mitigation that you all know about. So no recovery of avoidable loss, the reasonable costs of attempting to mitigate are themselves recoverable, and the third one, no recovery of avoided loss. And all of this is tied to that third rule in McGregor. But it's not just about mitigation, because the same principles apply whether you're talking mitigation or whether you're simply talking about causation. So the relevant benefits may derive from the actions of third parties. The relevant benefits may derive from the claimant's actions at a time prior to the claimant being aware that a breach has actually taken place. Both of those things may give rise to benefits which wouldn't classically be classed as mitigation, but which may nevertheless have to be taken into account. And there's a long string of judgments, but particularly the Elena de Amico, which say, look, mitigation, causation, those 2 doctrines are completely tied together. Mitigation is merely a subset of the broader causation principles in this area. So what are the principles, or are there any principles? And that's really what I'm focusing on. I think Chapter 9 of McGregor lists several hundred cases in this area, which isn't particularly helpful in trying to distill what it's all about. But some examples perhaps illustrate the apparent inconsistency in the way that the courts deal with things. The classic case, the easy one that you all know about is, well, if you get benefits from an insurance policy, or because your rich aunt pays you out some money to help tide you over when things went wrong, those are collateral benefits raised into alios acta. They don't fall to be taken into account, and the courts have been saying that since the middle of the 19th century. But more recently, Rubenstein and HSBC Bank, well, that was an investment in a financial product, in a fund which went bad. There was no legal right to recovery from the fund, but a gratuitous payment was made. Now, ordinarily, a gratuitous payment would be excluded, but a gratuitous payment of that kind, because connected in some way to the breach, was taken into account, so it did reduce damages. So what's the reconciliation between those 2 lines of authority? Similarly, in mitigation, the classic case on mitigation is British Westinghouse. You get sold some defective machines, you replace them ultimately with some much better machines. Obviously, you've got a damages claim relating to the cost of replacing the machines. but the damages were reduced for the efficiency gains that the new machines generated. That was a benefit which fell to be taken into account. On the other hand, Hussey and Eels, a house purchase case, for those who remember it, the claimants bought a house that was represented to be free of subsidence. It was in fact subsiding. They obviously had a claim for that. They couldn't afford the costs of the remedial work. So because they couldn't afford the remedial work, they went through a 2-year process of obtaining planning permission so that they could knock the whole house down and build another one. But having got the planning permission, worked out that it would be much more effective just to sell the house. They made a big profit on the turn, selling it with planning permission. And the argument for the defendant then was that that profit should be taken into account in reduction of the damages, but the court would not allow that profit to be taken into account. It said all of that activity, although transparently an attempt to mitigate the obtaining of planning permission and then ultimately selling the house, nevertheless generated a benefit which was regarded as collateral and insufficiently connected and something that they were entitled to keep. The last example, Laverack and Woods, nicely set it up because it has the juxtaposition within the case itself. So a senior manager or director of the company was unlawfully dismissed, and in his claim for damages for repudiation of his contract, the question arose what his loss was. He had moved to new employment in a company in which he also took shares, and he had at the same time invested in one of the defendant's competitors, which was something that he also could not have done while in his employment because of the conditions attached to his employment. So both things that he manifestly could not have done but for being dismissed. The increase in the value of the shares of the company that he was working for and in which he held the shares was taken into account. The increase in the value of the shares in the other company was regarded as collateral. Now, again, why? What is the logical basis for that distinction? Both of them were investments that he could only make because of the repudiation, and nevertheless only one of them was regarded as sufficiently closely connected to be taken into account. So, not a very satisfactory basis for saying what the principles are. Relatively recent decision in 2014 tried to take it a little bit further and distill all the principles from all the cases, and that's Fulton Shipping of Panama and Globalia Business Travel, which is a case about a charter party. And Popperwell J boiled it down to what he thought was 11 principles. I've actually summarized his principles down a little bit more, down to 6. Although one can go into the more granular detail. He said, well, it's a question of causation in all of the circumstances, and that is causation of the benefit. A reasonable response to the breach the breach may trigger somebody to do something, reasonably to do something. It does not follow that the outcome of what they did is necessarily legally caused by it, even if it is factually caused by it. He said that the benefit must be caused by the breach, not merely by the mitigating step. So you can't simply look at, well, did the breach lead you to take the action in mitigation? Did the action in mitigation lead to the benefit? You've got to tie the benefit back to the breach itself. Causation, he said, is a matter of degree. The benefit need not be of the same kind as the loss. And at the end, the catch-all, justice, fairness, and public policy may make all the difference. Now, that may not be a very precise set of principles, but it was at least an attempt to pin everything down. What did the Court of Appeal do with it? Court of Appeal in 2015 had 2 cases, both of them the most substantial judgment is delivered by Lord Justice Longmore, and both of them reflect back on Mr. Justice Popperwell's decision in Fulton Shipping. The second one is, in fact, the appeal from Mr. Justice Popperwell's decision in Fulton Shipping. So the first one is Swinson and Loic Rose, case which illustrates some of the points that Joe was summarizing. So Mr. Hunt owned a company, Swinson. Swinson lent money to another company called E in the judgment, so I'm simply going to refer to it as E, which was being bought out in a management buyout. And as part of that transaction, obtained a due diligence report from the accountants before deciding whether to make the relevant loan. Got a bad due diligence report. It turned out that E was very much less profitable than had seemed to be the case, and was in a great deal of financial trouble and was not going to be able to repay Swinson, the company which had made the advance. Swinson therefore wanted to sue the accountants for the loss of the recoverability of the loan. So far, so straightforward. But Mr. Hunt decided that he wanted to refinance E, the company at the bottom of the structure. So he gave some cash to E, which used it to repay the debt to Swinson. So at that point, there no longer was an outstanding loan. Swinson had been repaid. And when the defendant raised this, saying, well, therefore, there is no loss, people obviously became a bit concerned. Swinson argued that was collateral. Now, Lord Justice Longmore, in this decision, said that Popperwell J's analysis in Fulton Shipping was illuminating, didn't go through it in a great deal of detail, and he said, well, those benefits were factually caused by what had happened, but did not arise in the ordinary course of business. And more particularly, he said, the difference between whether the loss was in Mr. Hunt or whether the loss was in Swinson was a matter of mere technicality, which is a source of some surprise to anybody like Joe that is thinking about reflective loss. His Lordship Mr. Justice Sales took a different approach. He said, well, this is all very unfair. Practical justice means you cannot deny Swinson's claim on the ground that Mr. Hunt happened to cause it to be repaid. If he had advanced the cash to Swinson directly, it would never have had to be taken into account, which is, of course, correct. And Lord Justice Davis, dissenting, said, in quite strong terms, that simply doesn't make any sense at all. The claim is a claim for the fact that a loan was made, which you say can't be repaid. The loan has been repaid as a matter of simple causation. There is no loss at all. And it is very difficult, it seems to me, to see why Lord Justice Davis is not right in that respect. Then, at the end of the year, the Court of Appeal could have another go in the appeal in Fulton Shipping. And I'll very quickly tell you the facts in that regard. The facts were a time charter of a vessel which was repudiated 2 years before the end of the charter. At the time it was repudiated in 2007, there was no alternative charterer available. And in consequence, the owners decided to sell the vessel, and they sold it for $23 million. 2 years later, 2009, if the charter, and the litigation obviously was ongoing in the meanwhile, if the charter had continued until 2009, what had in fact happened is the bottom had truly fallen out of the charter market, and by then the vessel would have been worth only $7 million. So when the owners sued for the loss of the hire for the period from 2007 to 2009, the repudiating charterers said, no, we did you a favor. You made $16 million on the turn by selling the vessel in 2007, when in 2009 it would only have been worth $7 million. And Popperwell J had been through his 11 principles and determined that that was a benefit which which should not have been taken into account. His Lordship Mr. Justice Longmore came now to consider the appeal, having described Popplewell J's analysis previously as illuminating, now said it is notoriously difficult to lay down principles as to when it is said the benefit is to be taken into account as avoiding loss. The judge is to be commended for trying, but hard and fast principles are difficult to enunciate, and it's all just indicative. So rather less enthusiastic on this occasion about Popplewell J's decision. Boiled down to saying there are no hard and fast rules at all. He's going to focus on the facts. And there was a critical fact which, for Lord Justice Longmore, made all the difference, which was that the sale of the vessel in 2007 had been undertaken in an attempt to mitigate. That was the factual finding on the evidence. And he said, well, once that is so, then the benefit falls to be taken into account. Firstly, that's not what the previous decision summarised by Popplewell J actually say. They say it may or may not fall to be taken into account. But secondly, what it seems to me to have ignored is the question of whether, but for the breach, the owners would have wanted to sell the vessel in 2009 at all. And in effect, what happened is they got stuck with the consequences of the fall in value to a time at the bottom of the market without there being ever being any evidence they would actually then have sold, which is a slightly harsh result. So where does all that get us? It gets to a position that there are more indicative examples. Instead of there being 100 cases in McGregor, there can now be 102, but little clarity. It is clear that factual causation is not enough, that you have to ask yourself whether the benefit is in some way associated with the breach, but at the end, that justice and fairness trump everything, which makes it all a rather open-ended, fuzzy inquiry. And that, to me, means fertile grounds for dispute, unfortunately. So in the advice that you give to your clients, not a great deal of comfort, lots of uncertainty in your practices as litigators, many cases, and lots to do. Thank you. Richard's now going to talk about something completely different, as it were, interest rate, swap misselling, and the like. Thank you.
One of those narrow areas, I'm afraid. Yeah, thanks, Tom. I'm going to talk about mis-selling of financial products and rattle through some of the more recent cases. Just to ground us, what are we talking about when we talk about mis-selling? Tends to be claims in misrepresentation, claims arising out of allegations that a bank has recommended or advised a customer to enter into an unsuitable product, or products that simply underperform. So cases where effectively you're told by the bank you're getting something fantastic, it's going to solve all your problems, and what you've ended up with is an expensive liability. That's my graphic illustration of that. So why do we care about these cases? Are they important cases? Well, there's a number of reasons. First of all, on the customer side, mis-selling leads to large losses that could and should have been avoided. On the bank side, there is reputational risk. Finding of mis-selling or accusations of mis-selling are damaging. In pervasive or chronic cases, we see regulatory intervention. I'm going to talk a bit about the Financial Conduct Authority redress scheme, and those lead to significant fines and large sums being paid out to consumers and customers. I see some of the figures there. Just in summary as to where the law is, I don't have time also to go back to all the history and start with Springwell and walk through all the cases, but the reality, it seems to me, is that things actually haven't changed all that much, and where we are is still in a position where it's very difficult for claimants to successfully bring claims against banks for mis-selling. I'm going to talk about two routes in particular. One is the usual civil claim through the courts, and the second is litigation arising out of the FCA review. That's a quasi-voluntary review scheme whereby banks have agreed to review some of their interest rate selling practices, and quite substantial sums have been paid out to customers. We're at the point where the review has largely been completed, but dissatisfied customers are now starting to try and find ways they can come to court to litigate the outcome. And as I'll explain, both of those routes are currently very bank-friendly. The main case I want to talk about is a case called Crestsign and NatWest and Royal Bank of Scotland. It's a case involving a family property business run by a Mr. and Mrs. Parker. The property business was financed by interest-only loans. They used to bank with Northern Rock until they decided that was a rather shaky proposition and decided to switch their lending over to NatWest. And in the course of the discussions with the bank, having some form of interest rate management product became one of the conditions of the loan. One of the key issues in the case centred around the sales pitch, and there was a significant conflict of evidence as to what had gone on. On the bank side, the bank said, well, we set out all the options, we gave you a menu to choose from, we explained all the products, and we stood back and let you choose. On the customer's side, they said, no, you pushed us into a particular product. And you see this interplaying quite a lot in the mis-selling cases, which tend to focus on the relative sophistication or lack of sophistication of the customer. I haven't come up with any better phrase for it than the dance of the idiot. It's where a customer who usually during the course of the negotiations thinks he's been quite clever, is playing the banks at their own game, is quite smart, comes in to court and says, actually, I didn't have a clue what was going on, I'm a complete idiot in all these things, and they knew that. The bank, who privately considered the customer an idiot throughout, then come to court and say, no, this guy is very sophisticated, knew exactly what was going on, we were very, very confident that he understood. And the court is left to decide, idiot or genius, and that is often quite a difficult judgment to make. In Crestsign, the judge came firmly down on the side of the idiot, with no disrespect to Mr. Parker. He was found to actually have made very clear that he didn't understand the products that they were discussing. And indeed, the judge found that the Parkers had misunderstood the interest rate swap in two crucial ways. One was that it was actually a separate contract from the underlying borrowing in the first place, which is a fairly elementary error. And the other is that it didn't match the term of the loan agreement itself. The judge found that the bank salesperson was a salesman to the core who had, in effect, pushed and recommended the particular swap that Crestsign ended up with, and that was ended up being a 10-year swap with a discounted rate for 2 years and then a fixed rate of 5.65%. They were originally in the money, then interest rates went through the floor. They were out of the money for a very long period of time and practically locked in because the borrowers couldn't afford to pay their way out of the swap and to pay the break costs that the bank would charge in order to, eventually to buy their way out of the swap and out of trouble. That brings us to the waivers. And the waivers in Crestsign are really what the case was all about. The contractual documentation and the presentations given from the bank to the customer contained a series of loosely described waivers and disclaimers. So there's a no advice clause, which effectively says we're not obliged to give you any advice, we're not giving you any advice unless we expressly agree that that is what we're doing. There's clauses that say that the customer satisfies itself as to the suitability of the product. There's a clause saying we won't rely on anything you tell us or any advice or any recommendations. And finally, there was a clause effectively disclaiming liability for any use of any information provided by the bank. So very pervasive attempts to exclude liability on one view or restrict the duties between bank and customer on another. So the claimants argued that the bank did have a common law duty of care when advising on these products or when making a recommendation. They argued there was a duty of care when providing information, that the information had to not only be true and accurate, but also be fit for purpose and essentially sufficient to enable them to make an informed decision about the products. They sought damages for misrepresentation and contended that insofar as the disclaimer, the waivers were exclusion clauses, they were unreasonable under the Unfair Contract Terms Act. The judge found that there was no duty of care at all when giving advice on the basis of the waivers. Now, they're referred to in the case law as basis clauses, and they operate effectively to save the bank in crest sign. They're called basis clauses because they define the basis of the relationship between the bank and the customer. They effectively serve to function as a starting point which says, we are not in an advisory relationship, we've disclaimed that. And what comes after, in crest sign, cannot change that. So the judge summarised the bank's position, which he accepted, as like this. Effectively, the salesperson is saying, although I recommend one of these products to you as suitable, the banks, that's NatWest and RBS, don't take any responsibility for my recommendation. You can't rely on it, and you must make up your own mind. But I really recommend it. It's really good, but don't rely on that. But it's really good, but don't rely on it. The information duty point, the judge found there was an information duty that was broader than simply being truthful and accurate, and that it could, in certain circumstances where you volunteer information, extend to a duty to volunteer sufficient information to enable an informed decision to be made. We found that it wasn't breached, both as regards to the nature of the product and their characteristics, but also specifically as regards the amount of the break clauses. Now, banks typically don't disclose the quantum of likely break clauses. They can't in advance, in effect, because they're priced to the market, but they were described simply as substantial, and the judge found that was sufficient to satisfy an information duty. The judge summed things up at paragraph 176 by saying that the banks didn't provide misleading information. They did provide negligent advice, but they had successfully excluded any duty not to do so. The judge went on to say that the bank did not show itself worthy of the trust Mr. Parker had placed in them, but unfortunately for Crestsign, the common law provides it with no remedy because the bank successfully disclaimed responsibility for the advice they gave. While the result may seem harsh to some, it's not the role of the common law in this court to act as a regulator. It follows that although I have considerable sympathy for Mr. and Mrs. Parker, I must dismiss Cressign's claim. So with that nudge towards the Court of Appeal, Crestsign successfully sought permission to appeal. And it was granted permission to appeal on 3 grounds. The first went to the basis clauses and their efficacy. Was the contractual documentation sufficient to exclude any advisory duty from coming into being in circumstances when the judge had found advice was actually given and was given negligently? The other 2 grounds of appeal relate to the scope and breach of the information duty. The appeal was due to be heard in April 2006, but unfortunately for me in my recent developments talk, it settled in February of this year. The banks decided, it seems, one can speculate, that the risk of a negative finding on the basis clause issue was sufficient to motivate them to pay off the Parkers, who at least got some of their money back. So that leaves us still in a very bank-friendly position. And that can be seen in a somewhat more recent case of Thornbridge, which is another interest rate hedging product mis-selling case. It's one of the few that's gone to trial. It's a Manchester case actually decided by Judge Mulder. It was a thumping win for the bank, it's fair to say. They won on pretty much every point. There were strong facts, and the bank benefited from having had a careful salesman in this case. But the court found no recommendation was made. But if it had, the basis clauses would have kicked in and saved the bank anyway, and no advisory duty, and no assumption of responsibility for any advice had come into being in the first place. The case also represents, if that's possible, a bit of a step backwards from the claimant's point of view, even from Crestsign. The judge found that the information duty didn't go any more broadly. Sorry, in the absence of any advisory relationship, an information duty didn't go more broadly than simply a duty not to misstate or misrepresent. So the Crestsign recognition there could be a wider information duty is still up for grabs. So that's a slightly bleak claimant position on the standard civil claims route. Just to say something quickly about the FCA review, there have been 2 recent developments in attempts to litigate the outcome of the FCA review. In Holmcroft, that was a judicial review claim whereby the disappointed Holmcroft was disappointed by the offer of redress it had received from Barclays, and it sought to challenge the process that had been followed by KPMG, which had been appointed by Barclays to oversee its redress programme. The divisional court found that KPMG wasn't amenable to JR, albeit it decided this not without some hesitation, and recognised there were strong countervailing arguments. It essentially took the view that its role simply didn't have enough of a public law flavour to warrant a decision that it would have been amenable to judicial review. That will probably go on appeal. We'll watch this space. It's not clear how valuable public law remedies will be in any event, as against KPMG in these sort of circumstances, and the court left open the possibility that disappointed beneficiaries of the redress scheme may have a contractual route. That brings me to Shawmime, which was a case decided last year, which was brought in both contract and tort as a claim suggesting that the FCA scheme rules weren't followed in the case of a particular customer. We're only at the strikeout stage, but the bank's move to strike out the claim in total was rejected. The court struck out the contractual claim and said there was no contractual relationship as between the customer and the bank as regards the FCA review itself. And the attempt to ground a contractual relationship in correspondence between the bank and the customer solicitors was struck out on the basis there was no consideration and no intention to create legal relations in that correspondence. The court left open to go to trial a tortious claim based on a duty of care on the White and Jones basis, which was the case where it was a disappointed beneficiary under a will who was found to be owed a duty of care by the lawyer drafting the will, despite the absence of any direct relationship between them. The only party that could have sued was the deceased, who was in a contractual relationship, but he'd suffered no loss and was dead. Similarly, in this case, the contractual relationship is between the FCA and Barclays, not between the customer and Barclays. So any claim that the scheme rules weren't followed only sounds as between Barclays and the FCA, but of course the FCA suffered no loss. So the argument, as in White and Jones, is that tort will rush in to plug the gap, and that you'll owe a duty of care to the customer as the intended beneficiary of the scheme. It's a creative argument. It's only survived a strikeout stage, but it's a glimmer of hope for disappointed customers, not least because it means you can start time running from the point at which the breach or the loss following the conduct during the scheme takes place. Many of these swaps are long since out of time for contractual or tortious claims. So this is a new chance to sort of restart a time running and get a claim off the ground. That's all I want to say on that. And with this, I'll hand over to Kyle, who's going to talk to you about disclosure and privilege.
Thanks very much. Well, to finish off this evening, I thought I'd talk about one particular piece of litigation, which is the Property Lines Group and RBS case. That is really for two reasons. Firstly, because it raises a number of interesting substantive and procedural issues, especially about disclosure and privilege. And secondly, it quite neatly brings together a big Manchester company and claimant and a number of barristers from Brick Court. So it's quite a helpful one for me. PAG itself is a Manchester company. It's a property investment and development firm, and quite a substantial one. RBS probably needs no introduction. One of the very large investment banks. It was the main provider of funding to PAG over the course of about a 10-year relationship, and all was very rosy, and they worked well together, had a very cordial relationship for most of that time. In the course of which RBS also happened to sell 4 interest rate swaps to PAG, which, as usual, proved to be completely disastrous. And then the relationship began to break down shortly after the financial crisis, eventually ending up with this litigation. essentially, PAG's claims can be broken down to three separate parts. You've got what is a fairly standard mis-selling claim, along the lines that Richard's just been discussing. The main claim is just a misrepresentation claim that various things were said about the swaps which aren't true. There's also a crest sign type claim saying that the information that was provided was completely inadequate or misleading. There isn't a general claim that there was negligent advice given by the bank. Very much of the other types of claims that were pursued in Crestline and Thornbridge. So perhaps the easiest way around basis clauses and other various disclaimers is just not to have the fight at all, which is the approach that's been taken in this litigation, and not really to bother with the odds that Richard was talking about. And the second main aspect of the claim is what we call the global restructuring group claims, or the GRG claims. Many of you may probably know already, but GRG is a division within RBS, or it was a division within RBS that's gained some notoriety. It was originally, or its ostensible purpose was to help people who were struggling borrowers who were in difficulty, and to get them back on the road to recovery and into what they called the good bank. It's unclear whether that was its true purpose. There was a report published in 2013 by a guy called Lawrence Tomlinson, who's a sort of financier and entrepreneur, and had some relationship with one of the government departments. He looked at a whole bunch of companies who'd been put into GRG and basically said there's a clear pattern of behaviour where GRG did one of two things. Either it identified companies who weren't really that bad but had very good assets and pressurised them in order to give up those assets, and they could then be sold off to various creature companies of RBS. There's another company called West Register, which then marketed all these properties and sold them off. So in difficult times, the bank could make money out of its customers. And the other illicit alleged motive is that the bank identified people who were problem customers, who were likely to bring swaps claims and other claims, and put them into GRG to put them under pressure and to keep them quiet. It's all very interesting and very topical still as to whether or not that's true. The bank obviously contests the Tomlinson reports. Many of its executives were hauled into Parliament to explain what GRG did. They then had to correct their evidence to Parliament when they said it wasn't actually a profit centre, but then it was. And Clifford Chance gave an independent report, but then they weren't independent, they were also their lawyers, which wasn't terribly satisfactory. Those executives then left. GRG was then disbanded. And against that not very auspicious background, PAG then brings effectively a breach of contract claim, saying that if you're a bank, in your facilities, you have a number of powers and discretions about how you can treat your customers. And in most cases, it goes without saying that you have to exercise those discretions in a certain way, you have to behave reasonably, you have to act in good faith. And certainly, to the extent that the bank has done any of the things that are described in the Tomlinson report, we would say, or PAG says, that that's a clear breach of those terms. So that's quite interesting. As far as we know, it's one of the early claims it was issued just around the time of the GRG report, so it's one of the first to do that, although there are a couple of others now. There's also several, I think there's at least 2 large class actions floating around, which have been through a number of different law firms and may well be coming to you soon. So it's quite an interesting area. There's been one interlocutory judgment in another case on it, but not very much to sort of determine the sort of legal claims that you might bring in this context. The last aspect is probably the best known, which is about LIBOR. Obviously, big revelations in 2012, 2013 about the conduct of various banks in manipulating the LIBOR rates. PAG brings a number of claims, one of which is to say that if you're proposing a swap which uses the LIBOR rate as an interest rate, as all of the PAG swaps did, it is implicit in doing that, if you are a large bank that has a hand in how that rate is set, that you make a number of representations to your customer, including that LIBOR is a true rate that isn't manipulated, that you yourself are not manipulating it, and that you have no reason to believe that other banks in your position would be able to do that. There's previously been one trip to the Court of Appeal in a similar case called Graiseley Properties, where the bank tried to strike out these allegations, and the Court of Appeal unanimously said they thought they were well argued. So Graiseley then settled, but as far as we're aware, PAG might be the first claim to go to trial sort of test these allegations at trial, which would be quite interesting. In terms of the story so far, given, perhaps unsurprisingly, given the sensitivity of the GRG aspects and the LIBOR aspects, it has a fairly chunky procedural history, which has thrown up lots of issues that have nothing to do with the subject matter of the claim, but have a lot to do with disclosure and privilege, and permission to amend, and the pleading of fraud, and other bits and pieces, which has been greatly interesting for the last year. So if you do get a chance, have a look at some of them. We've covered almost every chapter in documentary evidence, legal advice privilege, without prejudice privilege, waiver, confidentiality. The one decision I thought I'd focus on today is actually one of the most recent ones down at the end, which is about litigation privilege and secret or covert recordings, which is, I thought was quite a fun issue, certainly quite fun to argue. And the question is, can you claim litigation privilege over secret recordings of meetings between potential witnesses? So I don't know if this is a well-known site. I don't actually know who the man with the very nice car is, but that's Frank Rostron's shirt shop in Manchester, which is the focal point of this case, and where various recordings were made. The facts are basically these. Shortly after the claim was issued, PAG's managing director, unbeknownst to any of his legal team, it should be said, met with a number of PAG's former relationship managers from RBS. He arranged these meetings on the basis that they should be catching up, or it might be a business opportunity, but actually his real motivation was to chat with them about what happened and try and get some evidence and information from them about what had secretly really been going on at RBS. And these meetings, for reasons that no one is really sure of, took place in some rooms above a shirt shop in Manchester, which the judge then became very interested in. Obviously, these recordings were made. As I'll come to in a second, it then became apparent during the litigation that these recordings had been made. RBS demanded immediate inspection of them. It became very agitated about what had been said by its former bankers. And PAG initially resisted inspection, saying that, well, it's evidence for litigation, they're covered by litigation privilege in the usual way. In terms of the test of litigation privilege, very straightforward. There's a very helpful summary from Lord Carswell in one of the many Three Rivers cases, Three Rivers number 6. Essentially, there's 3 elements. You to know if there's litigation that's actually on foot or in reasonable contemplation. The nature of that litigation must be adversarial as opposed to an investigation or an inquisition. That requirement usually doesn't arise unless you've got something like a regulatory investigation. Most litigation would be covered. And the last one, which is the one where most debate usually happens, is what was the purpose of the document being created? Is it the dominant purpose of that document or communication for litigation, or does it have a dual purpose, or was it really for something else entirely? So it was that last limb of the test that really this little bit of the case was about. Were these recordings of these meetings made for the dominant purpose of litigation or for a different purpose? The first issue for Mr. Justice Burst was actually the starting point itself. Should he look at the recording, the document over which privilege was claimed, or the data source over which privilege was claimed, or does he look at the underlying meeting and the purpose of that and the communications that happened there? You might think it's the recording, because that's the thing that's being withheld from inspection. That's the thing over which privilege is claimed. And it's pretty obvious that the purpose of the recording is to gather evidence for litigation. It was never suggested that Mr. Russell had any kind of interest in collecting audio recordings of bankers chatting in shirt shops, but for finding out what they knew about his case. The judge eventually decided without actually much hesitation, that is not the right approach. You have to look at the underlying communication and the thing that is recorded and determine what the purpose of that was. So the major consequence of that is actually solicitor's attendance notes. If you make a note of proceedings in open court or a call with someone on the other side, ostensibly that note is not privileged to the extent it just records something else that wouldn't be privileged. And if you make notes in the margin saying advise client as follows, that might be different. But it occasionally does come as a surprise to people that something that they have recorded privately could be disclosed in proceedings. The next issue, having decided what to look at the communication itself, was what was the purpose of the meeting. And PAG says it's pretty straightforward. The purpose of the meeting was Mr. Russell's purpose. He'd set it up to gather evidence. He was the creator of the meeting. No one disputed that was what he was doing, and it should be privileged in the usual way. We said it was absolutely indistinguishable from the situation where a solicitor decides to gather evidence and it goes out, and that he or she goes out to meet a potential witness and asks them what they know about the case and makes a note of that. We said it's absolutely the same thing. It doesn't matter what the witness thinks. The witness might want to come and have a drink with you because they like you for other reasons, but you're there to gather evidence of litigation. It's your meeting, and that's what matters. The bank said, well, you have to look at this objectively. It's a bit like contract. You look at what passed between the parties, and the other people turning up to the meeting thought, well, it was about a business meeting or something like that. They didn't know what the secret purpose of the meeting was, so you have to look at it objectively. The judge wasn't very persuaded by that, thought that was all very artificial. But in the end, he said it doesn't really make sense if you've got something where there are cross purposes, where someone turns up to a meeting thinking it's about X and someone thinks it's about Y. It doesn't really make sense to work out what the dominant purpose of that meeting is if no one really knew what the purpose was. But he said in those circumstances, the key point that makes the difference is that one of the parties was misled about what they were doing there, and in those circumstances, PAG couldn't really complain if it wasn't able to assert that the purpose of the meeting was litigation, and therefore he ordered inspection. In terms of practical consequences of this decision, you might think was pretty unusual facts and wouldn't come up very often in commercial litigation, although you might find, and certainly as we found, you might occasionally be surprised by what a client brings along and suggests as be helpful evidence. I'm told it happens actually quite a lot in employment cases where people record their employer in circumstances they say are being discriminatory or oppressive, and they try and use that recording. So that is where it may come up. The basic effect of the decision is that care is required from proofing any witness. Effectively, the result of what Burse found is that you have to be upfront with your witnesses. You have to tell them what you're about. You have to tell them that you're there to gather evidence for a potential claim. And if you don't do that and you mislead them as to what you're doing, then you may not be able to claim privilege over your notes of that meeting. And the final point is actually that they, even if you can't claim privilege, it is still possible that that recording might be admissible in evidence, which is the result of those few employment tribunal decisions just listed at the end there. I was going to say that actually that is obviously the effect of the decision. There are a number of criticisms that could be made of it, to the extent that it doesn't probably follow from the authorities that are cited, because they're dealing with a slightly different situation of recordings of inter-parties communications as opposed to communications with a third party. So if you're dealing with a meeting between two parties of the litigation, it could be said that that meeting could never be confidential and therefore privilege could never be claimed over it. But that doesn't necessarily follow when you're meeting with a third party. And you could say that's a confidential meeting with a third party who you're gathering evidence from. And there are other issues about estoppel, which is in some of the cases it said, if you tell someone that you're meeting them for a business meeting, you are then stopped from subsequently asserting that what you were doing there was meeting them to gather evidence or meeting them for another purpose. Again, that makes more sense when you're meeting with another party to the litigation, because you're making a representation to that party relied on it, and that party can assert an estoppel. To my mind, it doesn't really make sense when you're meeting with a third party. In this case, what representation did Mr. Russell make to RBS? In what sense did RBS rely on that representation as opposed to the bankers he was meeting with? The legal analysis just doesn't work. So lastly, you're really left with a question of policy. Should secret recordings be privileged? Should that be something that the law protects from inspection? And the judge was quite persuaded by the argument that actually the purpose of privilege is to allow people to discuss matters in a safe space, protected from prying eyes and inspection. I think that's probably true with legal advice privilege, but it's unclear whether that's the same with litigation privilege. I mean, historically, that's been about allowing people to pursue their claims effectively and about gathering the best materials that they can have for that purpose. It seems to me that policy would apply to these recordings in the same way as it would a written proof of evidence for a particularly useful witness. Just finally, before I'm sure Tom's about to release you all quickly to the bar. One last point to note is the potential sting in the tail. These recordings came out because the solicitors had inadvertently disclosed a privileged email that referred to them. It was an email between a solicitor and the client, which basically said, we should talk about the secret recordings. I want to find your comments on the secret recordings. What comments do you have? Which gave the game away, one might say. Obviously, perked the bank's interest in what these documents were and why it could not see them. But the lesson from the case is that to sort of take a breath and think through your obligations when you've inadvertently been given some privileged documents. Because what the bank did in this case was it ran off and got witness statements and showed this email to everyone, and they all talked about it and put in loads of evidence. And of course, the first point Burst made was, well, hasn't this been disclosed by accident? Don't you have obligations to raise this and to seek the permission of the court to do things with it? So despite winning on the substantive point, the bank was then awarded none of its 100 grand cost bill, which is perhaps a harsh but salutary warning from this little piece of litigation.